Right, that looks like everyone's in. Welcome and thank you all for coming to our webinar this morning on the commercial rent coronavirus bill, which is due to be enacted on the 25th of March. My name is Vicky Cantiker, for those of you who don't know me, and I'm a partner in the property dispute resolution team here at Lodders. Our property dispute resolution team is one of the largest teams of property litigators outside the traditional big firms. We've got our lovely team up on the slide. Currently have two partners, James Senior and I, our senior associate Ellie, an associate solicitor Lauren, who is speaking today, and three assistant solicitors, Katie, who is also speaking, Chris and Laura, and all of us specialise in contentious property issues. We also shortly hope to be joined by a couple more. Lauren and Katie are giving today's presentation, which will last for around 30 minutes with an opportunity for questions at the end. If you can use the Q&A function on your screens for putting questions in, they can all then be looked at the end of the presentation. The webinar is being recorded and it will be available afterwards on our website. Our team has dealt with numerous arrears issues for both landlords and tenants throughout the pandemic, recovering substantial sums for landlords where appropriate. We want to talk today about the process for dealing with any continuing outstanding arrears and how that's changing and why you need to know about it. We just want to start with a very quick poll. How many of you are acting for landlords or tenants where there are still substantial long-term rent arrears outstanding? If you could just answer the poll on the screen, and we'll just give a moment for those to come through. How are we doing, Colin?
Yeah, we've got 90%. So I think, 92. Yeah, so I'm going to end the poll now.
Put the result up.
There you go.
Mostly landlords. So there's the vast majority of you, 73%, have got considerable arrears still outstanding. Nice to see those of you that don't, which is perhaps a good sign. But it does appear that there's still quite a lot of issues and a lot of arrears out there that need dealing with. So the rest of this presentation will be particularly relevant to you. I'm going to hand over to Katie now to start the formal part of the presentation, and we'll pick up at the end with the Q&A. Thank you.
Thanks, Vicky. Good morning, everyone. So today we're going to cover what do landlords and tenants need to pay attention of the bill for, who the bill will apply to, what does the bill aim to do, how will the bill affect current restrictions in place for landlords, how will it affect proceedings for rent arrears going forward. Then Lauren will go on to talk about the new arbitration procedure, some areas of concern that have been identified with the bill being brought in, and then, as Vicky said, we'll have the opportunity for questions at the end. So, following the enactment of the Coronavirus Act and subsequently the Corporate Insolvency and Governance Act in 2020, landlords' ability to take action against commercial tenants defaulting on rent payments has been considerably restricted during the COVID-19 pandemic. The passing of the CA and SIGA has meant that landlords have not been able to forfeit leases on the grounds of unpaid rent, and landlords' other available remedies to recover outstanding rent have also been notably curbed. So they haven't been able to use CRA, for example, and their ability to use winding up petitions has also been restricted somewhat as well. So further to the introduction of the CA and SIGA, on the 9th of November 2021, the Commercial Rent Coronavirus Bill 2122 was put before the House of Commons with a view to the bill being passed as law on the 25th of March 2022. Since that date, it's not been possible to sue for rent arrears. So why do landlords and tenants need to take notice of this new legislation coming in? Well, once enacted as law, the bill will create a mandatory structured forum for landlords and tenants to negotiate rent arrears accrued during the COVID-19 pandemic. This will be via a new arbitration procedure. Whilst the bill may be helpful for both parties, landlords and tenants need to pay attention, primarily because if the arbitration process is engaged by one party, then the other has no choice but to engage with it. Use of the arbitration procedure is not optional, and once a reference is made by either party, the other is required to take part. Landlords should take notice because it will allow them to claim back at least some of the rent arrears they have been barred from recovering for so long. Whereas tenants need to pay attention because it might allow them to mitigate their arrears and significantly reduce the rent debts that they have accrued during the COVID-19 pandemic. Arguably, it's more important for landlords because despite them being given the opportunity to recover some of the monies due to them, it also brings in further constraints on actions they can take against tenants in relation to protected rent debt, which I will discuss later on. However, a very important point that landlords and tenants both need to consider is that the bill will only deal with outstanding arrears at the 25th of March 2022, which is obviously the date that the bill will come into law. If the arrears pre this date have already been recovered, then the provisions of the bill and the new arbitration procedure won't apply because, of course, the landlords will already have had their money back. So, who will the bill apply to? Section 2.5 of the bill, as it's currently drafted, confirms that it will apply to business tenancies as defined by Part 2 of the Landlord and Tenant Act 1954. The bill therefore catches tenancies where the property is wholly or partially occupied by the tenant for the purposes of the business carried on by him, and include leases, under leases, tenancies by estoppel, periodic tenancies, both express and implied, and also agreements for lease or under lease. It's also been noted that a lease contracted out of the Landlord and Tenant Act 1954 will be considered as a business tenancy for the purposes of the bill. However, licenses, tenancies at will, and other tenancies excluded from the 1954 Act, so things like farm business tenancies, tenancies of less than 6 months, won't be caught. Head leases where the head tenant has sublet and is not itself in occupation of the property also won't be caught by the Act, so that's just something to bear in mind. So moving on to what the bill aims to do. As I mentioned earlier, the main purpose of the bill is to establish a forum by way of a new arbitration process for commercial landlords and tenants to negotiate claims for unpaid rent arrears. The arbitration process will deal with the arrears which have accrued in periods where commercial tenants have been forced to close their business premises due to government rules during the COVID-19 pandemic. Excuse me. This period is defined by the bill as the protected period. The protected period, if you could just pop along to the next slide, please. Thank you, is the period beginning on the 21st of March 2020 and ending on either the earlier of the date that the tenant was able to reopen in line with relaxation of restrictions, or the date that all government restrictions were lifted. So in England, that was 11:55 p.m. on the 18th of July. And in Wales, that was 6 a.m. on the 7th of August 2021. So just to sort of exemplify that for you, the protected period for non-essential retail, which reopened on the 12th of April 2021 in England, would be shorter than the protected period for nightclubs, which reopened on the 18th of July 2021 in England, obviously being one of the last sectors which were allowed to fully reopen in line with COVID restrictions. Also note, businesses that weren't subject to any sort of closure requirement will not be caught by the bill. So again, that's something to bear in mind if you've got tenants that haven't had this closure requirement enforced upon them. So moving on from the protected period, the rent accrued during the protected period has been called protected rent debt in the bill. It provides definitions for both rent and protected rent debt, and I'll read these from the slide just for ease because they're quite wordy. So section 2.1 of the bill defines rent as an amount payable by the tenant to the landlord, including any person acting for the landlord, under the tenancy for possession and use of the premises, whether described as rent or otherwise, including VAT chargeable on that amount. Rent also includes an amount payable under the tenancy as a service charge, including any VAT chargeable on such amount, and interest on any unpaid amount within the definition of rent or service charge. It's worth noting here that the scope of service charge for the purposes of the bill is very broad and includes, amongst other things, fees payable for services, repairs, maintenance, improvements and insurance costs payable to or by the superior landlord. So moving on to the protected rent debt, this is defined as rent due under a tenancy that was adversely affected by coronavirus, i.e. there was a closure requirement and it needed to close its premises at some point during that protected period. And the rent is attributable to a period of occupation by the tenant for or all of the protected period. So again, that closure requirement. If an agreement between a landlord and tenant can't be reached in relation to a protected rent debt for the protected period, the parties will have 6 months from the date of the bill being passed as law to then refer the matter to the new arbitration process. Currently, this means that a party will have until the 25th of September 2022 to make their reference to the arbitration scheme, but this may be subject to an extension if it's seen as required. So moving on, how will the bill affect current restrictions in place for landlords and how will it affect them going forward? If the bill is currently enacted as currently drafted, the current moratorium on landlords' remedies will expire, but will be replaced by a new moratorium which imposes further restrictions on landlords' available remedies whilst the arbitration process is ongoing. It's important to remember that the moratorium under the bill will only apply to unpaid rent for protected periods where a business was subject to forced closure, so forfeiture for other defaults could still be available. This again reiterates that tenants who are not forced to close won't be caught by the bill, so the arbitration process won't apply here. So looking at claims issued by landlords before the bill was put before the House of Commons, so that's pre the 10th of November 2021, as it stands, the bill will not affect proceedings commenced against defaulting tenants before this date. However, landlords must be wary that for claims before the 10th of November 2021, the provisions of the Coronavirus Act and the Corporate Insolvency and Governance Act still apply, and they will continue to do so until the 25th of March 2022. So essentially, once the bill is enacted, the current restrictions in place will drop off and then will be replaced by the new provisions in the bill when it comes into law. So for claims issued between the 10th of November 2021 and enactment of the bill, so 25th of March 2022, the provisions detailed in the CA and CEGA will continue to apply until 25th March 2022. However, as previously mentioned, there are various other restrictions that will come in to replace the current moratorium once the bill becomes law. These new measures under the bill will then apply retrospectively to claims issued between 10th November 21 and 25th March 22. As drafted in Schedule 2 of the bill, the provisions of the new moratorium will apply retrospectively, which mean that firstly, either party to proceedings involving a protective rent debt may apply to the court for proceedings to be stayed so the arbitration scheme or other ADR can be used. If a party does this and makes the application to the court, then it must be noted that the court must grant the application for the stay to be allowed. Secondly, if a judgment has already been given in respect to the claim, but the protected rent debt or any interest on it is unpaid, the matter can still be referred to arbitration. However, if the arbitrator makes an award giving the tenant relief from payment, or if the parties reach an agreement on the unpaid amounts otherwise, any judgment debt will be taken as altered in accordance with the award or agreement. And then finally, the landlord may not otherwise enforce or rely on the judgment during the moratorium period, so it can't otherwise be enforced against the tenant. Turning to claims that will be issued after enactment of the bill, As currently drafted, the bill will prohibit landlords from pursuing certain remedies during the moratorium period. So the moratorium period is defined as the date that runs from enactment of the bill, which then runs to either the last day that a matter may be referred to arbitration, i.e. 6 months after. So at the moment, it would be the 25th of September 2022. Alternatively, if the matter has been referred to arbitration, the moratorium period ends on the day that the arbitration concludes. So it might be slightly sooner than that 25th of September date. The bill will then, or the bill is currently drafted, sets out that during the moratorium period, landlords cannot do any of the following in relation to a protected rent debt. So they can't start a debt claim, they can't use CRA, they can't forfeit a business tenancy, they can't seek to rely on failure to pay for the purposes of opposing a lease renewal under Section 30 Ground B of the Landlord and Tenant Act 1954. They're not able to use a rent deposit to put towards an unpaid protected rent debt. They can't require a tenant to top up a rent deposit where the landlord has already drawn down a deposit before the beginning of the moratorium period. They can't appropriate rent to rent debts, so any rent that they receive in must be offset against what are unprotected rent debts. So that would be anything that was accrued pre-21st of March 2020 or after the end of the protected period for that particular tenant. And in certain circumstances, landlords also can't present winding up or bankruptcy petitions against tenants or their guarantors in respect of protected rent debts. It should also be noted that neither the landlord nor the tenant can initiate the arbitration procedure in relation to a protected rent debt during the moratorium period, other than by using the new set procedure under the bill, unless the parties agree otherwise, and then a different method can be used. So that was a whistle-stop tour of who the bill will apply to, what the bill aims to do, and how it will affect restrictions on landlords and claims against their tenants. I'll now pass over to Lauren to set out the procedure for the new arbitration process in a little more detail. Over to you, Lauren.
Thanks, Katie. Good morning, everyone. So I will take you through the new arbitration procedure as we currently understand it. So whilst it's being finalised by Parliament and in anticipation of the bill being enacted, a draft guidance note has been published, so we have a better idea of the arbitration process, what it would involve and how it will work in practice. This guidance note is currently only in draft form for now, so some of the provisions may change once the bill is made law. So how will the arbitration process work? There are 3 stages of the process which I will take you through. So we've got stage 1, the pre-arbitration stage. This sets out all of the steps a party must take before they're able to make a reference to an arbitrator. This reference, as Katie said, must be made within 6 months from the day the bill is passed as law. This could be subject to review and may be extended in the future, as we saw with other COVID restrictions placed on landlords and tenants, but we'll have to wait and see. Either the landlord or the tenant can submit a reference to an arbitrator, but whichever party intends to make a reference must comply with certain requirements. The guided note sets out that steps include notifying the other party of their intention to make a reference, allowing the prescribed period of times to elapse before making a reference, and ensuring that the reference is made to an arbitration body approved by the Secretary of State. So once a party has given notice to the other of their intention to make a reference, the other party has 14 days to submit a response to the notice. If a response is received, then the reference to the arbitrator may be submitted after 14 days from the day after the response was received. If no response is received, then the reference to the arbitrator can be made once 28 days from the date of the notice of intention to make a reference has expired. So once those relevant periods have elapsed, the reference process is then started by the applicant giving notice in writing to an approved arbitration body, requesting that the body appoint an arbitrator to assist the parties. The applicant is required to pay the arbitration fee at this point, and any reference to the arbitrator must also contain the applicant's formal proposal for settlement. It's important to note here that a reference cannot be made if a tenant is a debtor under a CVA or an IVA. So landlords must be mindful of this, particularly if they're aware of the tenant being in financial difficulty, and you can check online registers that are available. So it seems like stage one creates a lot of hoops to jump through before the arbitration process can actually begin. But the guidance note does explain that the primary function of stage one is to allow the parties involved to negotiate and potentially resolve the dispute without a reference being made at all. It looks to promote settling disputes without the need for the arbitration, which is likely the most cost-effective way for parties to deal with the protected rent matters. However, after 2 years of rents being accrued, it's unlikely that aggrieved landlords and tenants with huge arrears are going to be on the same page when it comes to negotiations. So we move on to stage two, which is the eligibility stage. The arbitrator determines whether the dispute is eligible for arbitration. So they must establish that the protected rent has arisen from a business tenancy as defined by the bill, and that the rent arrears are in fact a protected rent debt, and that the parties are not in agreement to a resolution. The definition of business tenancy and protected rent debt was set out earlier by Katie, so I'm just going to focus on the meaning of relief from payment. The bill and the guidance note suggest that the questions which need to be asked in relation to relief from payment are: is there a protected rent debt? And if so, whether the tenant should be given relief from payment of that debt, and if they can be given relief from payment, what that relief should be. If the arbitrator deems that there's protected rent debt and the tenant should be allowed relief, there are certain awards that could be made. So the arbitrator could decide to write off the protected rent debt in its entirety, give the tenant time to pay off the debt, including the option for the tenant to pay by instalments, or they could reduce or write off any interest payable on all or some of the protected rent debt. At this stage of the process, if the arbitrator is not satisfied that the eligibility criteria are met, they must make an award dismissing the reference. They must also make an award dismissing the reference if the parties have been able to reach an agreement without their involvement, or the arbitrator does not think that the tenant's business is viable, nor would it be viable if an award from relief from payment were made. Within the bill, viability of the tenant's business has not been expressly defined, and therefore the arbitrator must consider this based on any evidence that the tenant can produce to them. The guidance states that the tenant is required to demonstrate viability of their business, disregarding the protected rent debt for the time being, as the government seeks to ensure that viable businesses are able to continue to operate. Therefore, the onus to provide evidence in support of the viability is on the tenant. So when the arbitrator considers the viability, they will have regard to the assets and liabilities of the tenant, previous rental payments made, the impact of COVID on their business, and any other financial information relating to the financial position of the tenant, such as bank account information, profit margins, evidence of refused applications for loan or credit, overdue invoices, tax demands. The list of suitable evidence in the guidance note is not exhaustive. However, the tenant must provide as much evidence to support their viability as possible. If the arbitrator is not satisfied with what the tenant has provided, they can request further evidence for their consideration and make an award to dismiss the reference, meaning that no relief from payment of the protected rent debt will be given. So we then move on to stage three, which is resolving the matter of relief from payment. So if the arbitrator has got this far and not dismissed the reference for the details in stage two, they must proceed to make an award of relief from payment for the tenant. They must consider whether the tenant should be entitled to relief from payment, and if so, then make an award on that basis. The parties will submit their formal proposals for resolution to the arbitrator to consider. As I said above, the formal proposal must be submitted by the applicant with their references, and it must be verified by a statement of truth. As well as the applicant submitting its proposal, the other party can put forward a formal proposal within 14 days of the applicant's reference to the arbitrator. Parties do have an opportunity to submit revised proposals to the other within 28 days of submission of their initial proposal. So this allows the flexibility and any amendments to be made based on any negotiations that are happening between the parties. Following the submission of the parties' formal proposals, the arbitrator will then need to consider a final proposal, which is either a party's original proposal or a party's revised proposal. If both parties have put forward proposals, the arbitrator must consider both and make an award based on whichever is most consistent with the principles set out in section 15 of the bill. These principles state that any award is to be aimed at preserving the tenant's business if viable, or restoring and preserving it if the tenant's business is not currently viable but could be with the right amount of relief, as long as the landlord's solvency is preserved. Unlike viability of the tenant's business, the landlord's solvency is defined by the bill. The bill states that the landlord is solvent unless the landlord is or is likely to become unable to pay their debts as they fall due. In assessing the landlord's solvency, the arbitrator must consider, as it does when assessing the tenant's viability, the landlord's assets and liabilities and other financial information which illustrates their solvency and financial position. The landlords are responsible for providing any relevant information and documents, however, they are not bound to do so. The same approach applies if only one of the final proposals is consistent with section 15. The arbitrator must make the award set out in such proposal, or if neither are consistent with section 15, the arbitrator must make an award as they see fit. If the only party making the reference has submitted a final proposal, the arbitrator must make the award set out in the proposal if it's consistent with section 15, but if not, they should make the award as they see fit, taking into consideration section 15. Once the proposals have been considered, the arbitrator will then make its award either to grant relief or not. Once you have the award, if at any point the award is breached, so for example, if the tenant has an award where they can pay by instalments and they fail to make an instalment payment, the award can be enforced pursuant to section 66(1) of the Arbitration Act, which means that with leave of the court, any award can be enforced in the same way a judgment or order of the court could against the defaulting party. So you have all of those enforcement options open to you. So from all of this, we can assume that it's quite an involved process, and we anticipate the main matter for the parties to consider here will be the costs of the process itself, as well as the costs of solicitors, accountants, other intermediaries who may assist with producing evidence of viability and putting together formal proposals. We still cannot be sure how much will be payable to the arbitrators appointed in these matters. In addition, it's to be seen how much weight the arbitrators will be put on evidence submitted by either parties, and we'll have to wait and see. So we move on to areas of concern. Given how quickly this bill has been drafted and its imminent enactment, there have been concerns raised about the effectiveness of this process. The main concerns raised have been the danger of inconsistency on approach between arbitrators, the risk of procedural unfairness during this process, and simply the creation of this procedure in such a short space of time. There's a general feeling that there is more work that needs to be done before the bill is passed as law, but given the deadline, is it now a case of it's too little too late? Matthew Ditchburn, the chair of the Property Litigation Association, has said, it's on the slide for you, but I'll read that out for you. It's clear that the bill is problematic in its current form, and a redrafting of key provisions is needed before it's made into law. This well-meaning legislation has the potential to destabilise fragile negotiations between property owners and occupiers, the opposite of what is intended, and we have some serious misgivings about the bill as presently drafted. As most of the measures relating to recovery of commercial rent introduced within the last 2 years seem to be in favour of the commercial tenants, the bill does seem to put more onus back on the tenants to prove they are deserving of a relief from payment. It does seem at this stage the government have acknowledged that landlords should have the opportunity to recover at least some of the arrears due to them, rather than continuing with the moratorium that has limited landlords' remedies relating to unpaid commercial rent for such a long period of time. We look forward to hearing more about the arbitration scheme once it's in practice and how onerous a process this will be for the parties involved. But as I've said earlier, it is a case of we will have to wait and see. And that's the formal presentation over. So if anyone has any questions, please use the question and answer box and we will do our best to answer them for you.
Thanks, Lauren. While we're just waiting for any questions to come up, I do have one that's come in. The new bill only deals with protected rent. Will you be able to take action for rent falling outside of that period that's previously been limited once the bill comes into force? Katie, what are your thoughts on that?
So because of the definition of protected rent debt being contingent on there having been a closure during the set period, anything that falls outside that definition, we think that rent arrears will probably be able to be dealt with as normal. So normal claims for the sort of rent arrears accruing by letters before action, that kind of thing. But like I say, because the definition does constrain protected rent debt so much, anything outside of that we think will probably just be recoverable as it always has been.
And there is the commercial code of practice relating to arrears as well that still exists, but I do wonder how much notice people will actually take of that, given that it's not a mandatory scheme, and probably for a lot of landlords they're just waiting until their remedies are no longer restricted.
Yeah.
I do have one other question that's come up. What if neither party makes a reference within the 6-month period?
Depending on whether the window is extended for applications being made to the arbitration scheme, presumably they just wait for that period to expire and then again deal with rent arrears as would usually, on the basis that it doesn't sort of fall into the protected rent definition and the period has fully expired. But as we've seen with the coronavirus, that period has been extended on a number of occasions, so there's no guarantee that the same won't happen. But
so there may though be some merit in landlords sitting tight and waiting to see if tenants make
perhaps
differences. Yeah. We've got another question. What if a debt is half protected and half unprotected and forfeiture is being considered rather than other remedies? Presumably, if you've got rent that is not protected, and providing that you haven't in any way waived the right to forfeit, you would be able to forfeit in respect of the unprotected rent, but not the protected. And what that practically means is that if the tenant then makes an application for relief from forfeiture, the normal position is that in order to gain relief, the tenant has got to pay the arrears. The tenant in that circumstance is only going to have to pay the unprotected arrears in order to get relief, and not the protected arrears, I would imagine. Obviously, it's all completely untested, but it seems to me that that's got to be the most sensible answer.
Yeah, because by the fact that half of the debt is protected, it means that to deal with that formally, you would have to use the arbitration procedures. There were the remedies for that part of the debt that wouldn't be available. But yeah, interesting point though. I hadn't thought of it like that.
I suspect there'll be quite a lot of that.
Yeah.
As soon as forfeiture is opened back up as a remedy. I'll just give it a minute and see if any other questions come through. Oh. So we have a question: if the tenant is a takeaway that was not obliged to close, presumably the arrears are not protected. So when can CRA be commenced? That's going to be a question of maths, I think, off the top of my head, although Katie, Lauren, jump in if I've got it wrong. I think the current requirement is that the arrears have to have been outstanding for 544 days, although that might not be exactly right, I think. So it will depend on when the arrears date back to, as to when that procedure can be instigated. But providing they're not protected arrears, then I'm right in thinking that you should then be able to institute CRA after the bill's been enacted.
It wouldn't be caught by this process because they weren't a business that was obliged to close. So it wouldn't be caught by the arbitration procedure. But yeah, you would just have to do the maths in terms of how long the debt's been outstanding for as to when you can commence CRA.
And I think that the sort of key expiry in this circumstance would be waiting for the moratorium to expire under the legislation that's currently in place, so the Coronavirus Act and SEGA, rather than then waiting for anything in the bill thereafter, because like Lauren said, it wouldn't be caught. So you just have to take notice of the current restrictions in place rather than any new ones coming in.
And I think that date is the 31st of March, isn't it?
The 25th of March.
Oh, right, fine.
Concurrently with enactment of the bill.
One further question, can we use rent deposits against protected debts if applied by the Act comes into force? So I think it's the question is whether you can use rent deposits and draw them down against protected debts. Katie?
I think that was one of the points that was raised on the sort of post 25th of March 2022 moratorium for landlords. I don't think we can, because the relevant part of Schedule 2 of the bill says that you can't draw down and then offset it against anything protected. There's no restriction on using it against unprotected rent debts, but if again the debt fits that specific definition, then I don't think you can use rent deposits to be offset. I'll check the slide because I know the wording's on there, but I don't want to give you the wrong information.
Further question, on lease expiry, could a landlord oppose a renewal on grounds of rent arrears if the arbitration process has been activated? Now, my understanding is the answer to that is no, you categorically can't rely on its ground B in respect of outstanding rent. You can't rely on that relating to protected rent or protected period, and that's currently prohibited by the legislation that's already in force as well.
It's not just if the arbitration process is activated by the parties, it's during that moratorium. So even if you aren't partaking in the arbitration process, it still applies. That's 6 months, you can't do it. Or if they extend it for the longer period.
Perfect. That's all the questions we have. So thank you very much for everyone attending today. As I said, the webinar has been recorded and will be available on our website shortly. And if anyone does want a copy of the slides, please feel free to email any of us. I've put our email addresses in the chat box, and we can send those over to you. Thank you very much.